You ever notice how the rules change when you're not looking? 1 month you think you know the ground you're standing on, and the next, it shifts right under your boots. September just proved it. The Supreme Court dropped a decision so sudden, so lopsided, that even seasoned court watchers didn't see it coming. 8 justices lined up on one side. Only one stood alone. That kind of unity almost never happens in modern America. And when it does, it means the system just hit a reset button. This wasn't paperwork. This wasn't legal noise. This was a warning shot that tore straight through decades of federal gun enforcement. The kind of move that doesn't just tweak laws, it guts them. And if you don't know what happened, you're already behind, because this ruling didn't just shake Washington, it handed raw power back to the states, left the ATF scrambling, and flipped the balance for millions of gun owners overnight. Stick close, because before this is over, you'll see why some are calling it the single most important shift for the Second Amendment in half a century. But to understand how earth-shattering this ruling really is, you have to see where the court has been heading. It started in 2022 with the Bruen decision. That case ripped apart decades of balancing tests where judges weighed public safety against individual rights. Instead, the justices set a new standard. If a gun law doesn't match the nation's historical tradition, the late 1700s, the early 1800s, it doesn't stand. Overnight, states like New York and California saw their carry laws collapse. Courts from coast to coast scrambled to dig up statutes from centuries past, trying to match modern restrictions with laws written when muskets ruled the battlefield. The chaos was immediate. Some courts tossed out age limits. Others gutted bans on carry in public spaces. Still others upheld restrictions on sensitive places like schools and courthouses. It was a patchwork map of conflicting rulings, and it put the country on edge. Then came Rahimi in 2024, a case about a man under a domestic violence restraining order who still wanted access to firearms. Many thought the court would stand firm on its strict history test, but instead, the majority said something different. The Second Amendment is powerful, but it doesn't shield dangerous individuals. That ruling showed the court wasn't locked in one gear. Sometimes it expanded rights, sometimes it limited them. The result? No one could predict the next move. And that unpredictability is exactly why September's 8-1 ruling hit like a thunderclap. So let's pull back the curtain on what actually went down inside the courtroom. 8 justices stood shoulder to shoulder, and only one said no. Now, let me ask you this. When was the last time you saw this court agree on anything with numbers like that? It doesn't happen. Not on healthcare, not on immigration, and yet, when it came to your gun rights, the consensus was crystal clear. And here's where it gets interesting. The lone dissent came from Justice Ketanji Brown Jackson. She warned this decision could make federal gun enforcement meaningless in half the country. But stop and think about that for a second. If even she admits federal control might collapse, what does that tell you about how strong this ruling really is? Now picture this. Sotomayor and Kagan, names you never expect to land on the pro-gun side, lined up with a conservative majority. Why? Because the writing on the wall was too bold to ignore. States have the constitutional authority to tell the ATF, not here, not anymore. 27 states already had sanctuary laws waiting in the wings. This ruling just flipped the switch for 165 million Americans overnight. And here's the question I want to throw at you. Do you live in one of those states? Because if you do, your rights just went from shaky to shielded in the blink of an eye. Now here's the part almost nobody mentions. The speed. These cases usually drag for years. This one, filed Friday, decided Tuesday. 4 days. That pace alone screams desperation. Federal lawyers begged for delays 3 separate times. Each time the court shut them down. Why? Because they had nothing. not a single precedent forcing states to help enforce federal gun laws. Their whole argument was smoke, and the justices saw straight through it. The ATF panic. Leaked memos showed 47 active operations in sanctuary states shut down on the spot. Imagine being mid-investigation and suddenly ordered, "Stop! You got no authority!" Within 72 hours, prosecutors were told to review every case, and some judges didn't even wait. They started tossing charges immediately. That wasn't just a defeat, it was a retreat. A scramble backwards so fast it stunned their own agents. And here's the question. If they folded this quickly, what happens when they try to push the next round of laws? Here's where the ruling turns from big to seismic. The court didn't just swat down one case and move on. No, they laid out a framework, a playbook that guts federal gun control at its core. 3 steps, clear as day. First, if a federal law clashes with established Second Amendment precedent, states are obligated to weigh its constitutionality. Not maybe, obligated. Second, if federal agents come knocking for help, states now have to ask themselves, would cooperation violate their oath to the Constitution? If the answer is yes, then the state must refuse. Not an option, a duty. And third, if both conditions are met, the state has the green light to stand down, to flat out tell the federal government, we're not your enforcers. Think about what that means. For decades, the ATF has leaned on local cops, state databases, and court systems to do their heavy lifting. By their own numbers, nearly 80% of enforcement actions depended on state cooperation. That support just evaporated overnight. Now imagine the tables flipped. Sanctuary states can legally warn citizens when the feds try to push questionable enforcement. That's not obstruction anymore. That's constitutional duty. And once that door is open, it's not closing. The message is simple but explosive. Washington no longer gets a blank check. The Constitution does, and the courts just handed states the pen to write the check back. And just when it looked like the court had drawn the line, they dropped the bombshell no one expected. States don't just get to say no anymore. They can strike back. If a federal agent enforces a gun law that doesn't hold up constitutionally, their shield is gone. No qualified immunity, no cover from DC. They're personally on the hook, and it's not theory, it's already happening. Within 48 hours, attorney generals from 31 states lined up civil rights lawsuits against federal agents who ignore this ruling. Imagine being ATF, once untouchable, now wondering if one wrong raid could cost you your career, your savings, even your home. Even insurance companies see the writing on the wall, warning federal agencies they may not cover actions taken outside the ruling. So here's the question. How many agents will risk it, knowing one misstep could ruin them? For the first time, the danger doesn't just fall on citizens, it falls on the enforcers too. And that flips the power dynamic completely upside down. Up until now, we've been talking about states flexing their muscles. But here's where it gets personal. This ruling doesn't just protect governments, it protects you. Picture this. You're in a sanctuary state and a federal agent knocks on your door. Maybe it's about a part kit. Maybe it's about ammo limits. Maybe it's about a rifle they suddenly decided looks too scary. Before you're on your own. Now, your state has the power and the duty to step in on your behalf. Missouri's Attorney General has already gone on record. His office will defend any citizen targeted by unconstitutional federal enforcement. Texas went even bigger, carving out $50 million for a defense fund to shield gun owners from federal overreach. That means if you're dragged into court, you won't be standing there alone. Your state is backing you. And here's the fallout nobody expected. Prosecutors are folding cases left and right. In just the first week after the ruling, 23 federal gun prosecutions were dismissed in sanctuary states. Judges flat out said, "We don't have the jurisdiction anymore." Imagine being hit with charges one day and watching them vanish the next because the ground rules changed overnight. For gun owners, this isn't just legal fine print, it's armor. It means the fight doesn't end in some distant court. It starts right where you live, with your state throwing the first punch to keep the feds off your back. Here's what no one on the news is saying. For decades, the feds built quiet dossiers on gun owners through DMV files, hunting licenses, carry permits, even local police reports. You never voted for it, but it happened. This ruling just cut the pipeline. Sanctuary states now have the right to slam the door, and 15 already did. Overnight, the ATF lost access to more than 800 million records. Half the map blacked out. Background checks now full of holes. Mental health files withheld. Criminal histories blocked. Purchase patterns gone. For the first time, the federal government doesn't know who's buying, where, or how much. So ask yourself, what happens to gun control when the rule makers can't even see the field? That's not regulation, that's panic, and it's unfolding right now. And this is where it all comes together. The future. Because the ruling didn't just shake up today's cases, it blew a hole straight through tomorrow's gun control agenda. Think about it. Every new law Congress dreams up now hits a brick wall the moment it reaches a sanctuary state. Universal background checks? Dead on arrival. Magazine limits? Same fate. Even so-called assault weapon bans. They can write them, but they can't enforce them without the states playing along. And now, those states have the Supreme Court's blessing to walk away. That changes everything. Why would lawmakers waste political capital pushing bills they know half the country can legally ignore? Why would agencies risk resources chasing cases they can't prosecute? The calculus is different now. The math doesn't work anymore. And the cracks are already showing. A universal background check bill that was expected to move this year suddenly stalled. Sponsors admitted, off the record, it's unenforceable under this new framework. Federal prosecutors in sanctuary states are dropping charges before they even hit trial, knowing they'll get tossed out. The system that once leaned on fear just lost its leverage. Here's the bottom line. For the first time in 50 years, Washington can pass whatever it wants, and states have the power to say no. That's not just a victory, that's a shift in the balance of power that could define the Second Amendment for a generation. So here we are, an 8-1 ruling, a fractured dissent, and a decision that just rewired the entire fight over the Second Amendment. For decades, the federal government acted like the final word. But this month, the Supreme Court reminded everyone that the Constitution cuts both ways. States don't have to bend the knee. Citizens don't have to bow their heads. And the ATF just learned what it feels like to blink. But don't get too comfortable. If history tells us anything, it's that the same politicians and agencies who just lost are already sketching out their next move. The battlefield has shifted, not disappeared. And the real test is what happens when the next big law hits the wall of this ruling. Will the states hold the line, or will DC find a new loophole to claw power back? That's where you come in. Which part of this ruling do you think changes the game the most? The state power to push back? The shield for individual gun owners? Or the fact that future gun control may already be dead on arrival? Drop your thoughts, questions, or even predictions in the comments, because this fight isn't just playing out in the courts, it's playing out in every conversation we have. Stay sharp, stay loud, and remember, the Constitution doesn't defend itself, you do.